Welcome to Emphasis Added, a podcast by the Houston Law Review about legal issues, prominent lawyers, and the study and practice of law. I'm Matt Chelf.
And I'm Brock Jones. We're your hosts, and thanks for joining us.
We're joined here today by University of Houston Law Center professor Emily Berman to discuss the Supreme Court's recent decision in Dobbs v. Jackson Women's Health Organization to overrule Roe v. Wade, what that decision means for the court's legitimacy, for other rights that are rooted in privacy protections, and for what we can expect from the new makeup of the Supreme Court moving forward.
Professor Berman is an expert on constitutional law, separation of powers, and national security. Her scholarship has been published in numerous prestigious law reviews, and she makes frequent media appearances to discuss these topics. Professor, thanks for joining us today.
Great to be here.
The Dobbs decision is still making headlines, with commentators, legislators, and activists all seeking to squeeze meaning out of the decision and how it would shape future policies. We'll talk about the decision's potential effects on other rights that stood on similar ground, as abortion, what the decision's impact could be on the people's perception of the court's legitimacy, and what we can expect from the court's upcoming term. But first, what were your initial thoughts when you read the Dobbs opinion?
I think my initial thoughts were that I was sort of shocked but not surprised in a way, because I think we all knew that it was coming, especially after the leak. But to actually read it in black and white was still really striking, and the tone of it was like, for someone who's getting to do everything on his wish list, Sam Alito sounds really angry about something, and I think that tone was just apparent, just so dismissive of alternative arguments, and I thought that some of that would be eased out after the leak. Before they issued the final opinion, and it really didn't differ from the leak. Mm-hmm. And it just gave me, I sort of feel like Dobbs is the beginning of something, not the end.
Yeah, so on that note, the dissenting opinion in Dobbs worries that the decision leaves the door open for the court to overturn other past decisions that might be reasoned similarly. The opinion actually specifically addresses the rights to contraception that were enumerated in Griswold, same-sex sexual activities and marriages from Lawrence and Obergefell. Now, Alito says in his opinion that this opinion is only applicable to abortion rights, and I think kind of tries to address your concern and says, like, don't worry about all of these other decisions. I'm only talking about abortion. But that obviously it is easy to worry about those other rights, because it doesn't seem like, he could really mean that when he says it. And then in Justice Thomas's concurrence, he pretty much specifically calls out all of those other substantive due process decisions, and says that they're erroneous and the court needs to correct those errors as soon as possible. So do you think that the court is open to overruling a bunch of those other previous substantive due process? I mean, pretty much the entire area of substantive due process as a tentative constitutional law? Or what do you think about moving forward?
Yeah, so I think, well, as you say, we know that Justice Thomas is open to that. Justice Alito and Justice Kavanaugh, to some degree, tried to be reassuring on that front. But as you say, if you take the legal reasoning of the opinion and apply it to any substantive due process right, you come out in the same way, or at least with respect to things like same-sex marriage. You come out in the same place that you come out in Dobbs, and I don't think that you can argue that their legal rationale wouldn't lead to similar results in other cases. Now, the one place where things might differ is they did do their stare decisis analysis, where they said, basically, we don't see any reason not to overrule Roe and Casey. When it comes to something like same-sex marriage that has really permeated the culture, and there are so many people out there that have relied on that and are living their lives assuming that that is an available institution, that may impact their view on the extent to which it's appropriate to overrule prior court decisions. But sometimes, I mean, maybe that's wishful thinking. I think they have outs if they want to make them. Whether they'll take them or not, we don't know.
So it's possible that to some extent public opinion is coming into play, in the sense that there may not be as much pressure, or the voting body might not have as much passion right now for overturning same-sex marriage as, the super hot topic divisive issue that abortion was.
Yeah, I mean, it's unclear. I mean, Alito was very direct in saying that public opinion should have nothing to do with anything. Whether or not that is actually, how things play out in his decision making, of course, we can't know. But yes, I think both with respect to the sort of desire to overrule cases and with respect to the way that it's embedded in people's lives, I think Obergefell is different from Roe in both of those senses.
So Dobbs also makes clear that abortion is not being outlawed nor condoned at all. It's simply being removed as a constitutional endorsement and being left up to the states to decide individually. Since the decision, a record number of abortion-related measures are set to appear on ballots in the upcoming state elections. And already we've seen Kansas voters voting against a constitutional amendment that would further restrict abortion in the state, an outcome that really surprised a lot of people. What should we expect from these measures? Should we expect more kind of similar avenues of people amending the Constitution and voting against that, seeing the voters really make an impact in that regard?
I think that's entirely possible. I think whenever we've seen evidence that anytime this question goes to sort of the people at large, whether it's through a referendum or through a public opinion poll, that there really isn't a lot of support for the most extreme positions. And people generally land, somewhere in the 15 to 20 weeks being a limit, with exceptions for life and health and rape and incest and those sorts of things. So I think it's likely that those referenda will pass, but only so many states have the potential for referenda. And in the states where, like Texas, there is no popular mechanism for getting a question like that on the ballot, we're really at the mercy of the legislature, which I think is gerrymandered in a way that doesn't really reflect necessarily the overall population of the state. And I think that's probably true in a lot of places where the abortion restrictions are sort of the strongest.
So we've talked about the plausible kind of slippery slope of this leading into other areas like gay marriage and contraception access, etc. But the court's upcoming slate isn't set to consider any of those issues, at least in the present term. What kind of are the major, hot button issues that you think they would be considering in the near future, if not those?
Yeah, so often when you see like a big controversial term, the next year will be like kind of quiet and the court will sort of take itself out of the spotlight. That is not what is happening this term. This term is set to be, I think, just as big, but focusing more on race relations and election law, some additional, pro-business potential cases, and also there's, First Amendment exemptions from anti-discrimination laws. So there's a lot of really high-profile cases that could really have huge impacts for the law and changes in the law that affect a lot of people.
It's crazy. It seems like half of our constitutional law course is being rewritten in the next year.
Tell me about it.
It's crazy. Making your
You
job
don't
a lot
have to write
tougher.
a syllabus.
Good luck teaching that again in the next semester. That'll be a blast, I'm sure. Entire syllabus just says TBD.
Yeah, exactly.
Basically.
So commentators have acknowledged that affirmative action cases the court has set here have the potential to define the term, much like Dobbs did this past term. It seems to be like the major hot button issue. What is the basis of the central basis of the issue the court will be deciding on?
So the court has taken two cases, one from a public university, one from a private university. And the question is essentially, do we overrule our existing affirmative action doctrine and say that the use of race as a factor in admission decisions is just comprehensively prohibited? That's what the petitioners are asking for, and I think it's what they're going to get.
And I guess, as a note, the 2003 Bollinger decision was the last, I don't know if it was the last, but it was the last major upholding of the race-based affirmative action. And I think it was Justice O'Connor at the time noted 25 years from that decision. She was hoping that it would no longer be needed. And I guess we are getting to that point of pretty close in the next 5 years would be that 25-year mark. But I'm not sure of a lot of the things that she was hoping would change have changed, unfortunately.
Yeah, I mean, I think if you ask the universities, they will say that maybe it has changed, but it hasn't changed sufficiently. And they have made the case quite strongly that in order to enroll the kind of diverse class that they're looking for, they need to be able to continue to take race into account.
Absolutely. In that particular issue, race-based affirmative action, we've seen, even in states like California that are traditionally very left-leaning, it's lacked popular support. It's a very divisive issue that doesn't necessarily follow along party lines. However, the court has the two other major issues you mentioned, the election laws and the business regulation, is something the court has leaned heavily right on in the past. What are the exact questions the court will be considering in those areas?
So there are two really potentially huge election law cases. The first, Merrill versus Milligan, which they'll actually hear in the first week of the term, is the latest in a series of challenges to the Voting Rights Act of 1965. And this one in particular is a challenge to Section 2, which prohibits voting procedures that are not equally open to participation by members of a protected class, like racial minorities. And it's frequently been used to strike down legislative maps that dilute the voting power of minority populations. And so in this particular case, there is a map in Alabama that was found to violate Section 2 of the Voting Rights Act. Alabama got an additional representative after the census, and so they had to redistrict. Mm-hmm. And it's quite easy there to build a map that includes two districts that would be what they call majority minority, so majority African American districts. But they only built one, and a 3-judge district court said this is a clear violation of the Voting Rights Act. The way that it would work is Alabama has 7 seats. More than 25% of the population is black, and the map that they drew would have 1 out of 7 representatives would be likely to be sort of a minority representative. So the district court ordered the state to draw new maps, and then the Supreme Court stayed that determination and put the case on the docket. So we're already going to have this year's elections are going to go forward with the maps that the district court, 2 of the judges being Trump appointees, said violate the voting rights of minorities. So that ship has already sailed. And then the question is, what, if anything, is going to be left of Section 2 of the Voting Rights Act after the court decides the merits of the case? And in some ways, it's really an echo of the affirmative action cases, in that there are several members of this court that want to eliminate all use of race in all decision making by all public officials. And so we've seen that play out in the Shelby County versus Holder opinion that struck down the preclearance requirement from the Voting Rights Act several terms ago. I think it's what's driving the affirmative action cases. And if they take that seriously here, it means there might also come out of this term a rule that public officials cannot take race into account in drawing voting districts.
Wow. It's the absolute colorblind route.
I mean, it's possible, and it seems like various opinions that different justices have written as this case has sort of been up and down between the courts, they seem poised to make some major changes to the Section 2 jurisprudence. Whether it will be that taking account of race at all is unconstitutional, I don't know, but it's a possibility, and certainly whatever they come up with is going to be less solicitous of minority rights than the whole history of the interpretation of the Voting Rights Act has been.
So is the plausible outcome of that then that state officials can't take race into consideration when drawing the lines, so the lines will be less biased, or you can't challenge the lines as being racially biased, so because theoretically they wouldn't have been on the basis of race at all, and therefore we're kind of stuck with severe gerrymandering?
Yeah, so currently the Voting Rights Act essentially gives plaintiffs the ability to bring a disparate impact case. And so if you get rid of that, then you're going to have to prove intentional discrimination under the constitutional standard. So I think you're right that it's not that they won't take race into account, it's that they'll use party as sort of a proxy, because there's a lot of overlap and it's sort of easy to see those voting patterns and know what they mean. And since the court has already said that political gerrymandering is a non-justiciable political question, it essentially opens up the states to do whatever they want to do, unless there's a state constitutional provision that might impact the case.
Wow.
Are there any other specific areas of constitutional law where this kind of absolutist, colorblind mentality might creep in and alter the law?
I mean, it could be in employment. It's really in anywhere that the Civil Rights Act says that you can sort of take into account the history of racial discrimination and the context in which, the Fair Housing Act. So all of those sort of anti-discrimination statutes potentially could be curtailed.
Pivoting into kind of our third major topic of the upcoming term, at the end of the last session, the court issued a ruling limiting the EPA's authority to regulate some types of pollution. The court is now set to hear Sackett 2, potentially further restricting the EPA's ability to regulate wetlands. Is this kind of another example of the court's recent laissez-faire approach to congressional regulation, or do you see it as more of a political attempt to curb forward progress in climate change policy?
Yeah, I think this case, it doesn't have the potential to have as widespread an impact as last year's EPA case did. This one is just about a particular provision of the Clean Water Act. And yes, I think they're going to limit the scope of regulation of the waterways of the U.S. is what it is. But so I think it's going to be a deregulatory decision, a sort of pro-business type decision, but it's not necessarily going to be another step towards sort of dismantling the administrative state, full stop, which is on some of the justices' wish list. So this case isn't going to do that, but it is likely to be a deregulatory decision.
Are there any other cases coming up in the term where there's potential for them to further deregulate and attack the administrative state? Is that something we're expecting?
There's none that I know of, but that doesn't mean there aren't any.
I guess they've only announced some of the cases that they'll be.
Yeah, they'll continue to add cases over the course of the term. So yeah, we could get more excitement down the road.
Looking forward to it, I guess. So in the month leading into the 2022-2023 term, we saw public outreach from justices addressing the legitimacy of the court, something we don't always see as candidly as they did this time. Specifically, Chief Justice Roberts supported the criticism of the recent rulings, but he took issue with such disagreement being a basis of questioning the institutional legitimacy of the court and its ability to interpret the Constitution. He was basically saying, it's okay to be upset with this, but it doesn't mean that we're not able or not doing our jobs. However, Justice Kagan spoke out very candidly against the court's supposed disregard of precedent and really reiterated the need to narrowly decide these cases to kind of reestablish the judicial legitimacy. What is the importance of judicial legitimacy for the legal system?
Well, I mean, in some senses, it's really the basis of the rule of law in the country. If people lose faith in the judicial system and come to see it as simply one more partisan tool, then there's really no incentive to abide by decisions handed down by judges that you don't agree with. And so really the court's ability to, the Supreme Court in particular, their ability to, as Marbury versus Madison said, say what the law is, comes only because the American people have sort of accepted that is an appropriate thing for the court to do. And when people lose faith that is an acceptable thing for the court to do, then we're in trouble.
Mm-hmm. It's kind of that theoretical concept, really, because it's, the eventual reality of that would be a total collapse of American civilization, I guess, in theory. It would destroy the entire legal system without the enforcement of the law. So how is that something, how can the court maintain or reattain that legitimacy? Because obviously they haven't lost it entirely, but it's something that's being talked about so often. They're struggling with it.
Yeah, I think, so there are a couple different mechanisms. I think one is we can hope that some of the talk has worried even those justices that are sort of full steam ahead on changing the law in the ways that they would like to. And maybe they become, or some of them become, more amenable to the sort of Justice Roberts, let's decide this case on a narrow ground and go gradually. I don't know if that's better or worse, because you're still headed down the same path. You're just headed down that path more slowly than you otherwise might be. But I think for the legitimacy of the court factor, moving more slowly would help them. I think the other thing that we have yet to see is how the political branches, and in particular Congress, respond to what the court does. So if it maintains its sort of full speed ahead attitude, then, and in other words, if it doesn't self-police, then rules might be imposed upon it.
Do you have thoughts on what kind of action that would be? I mean, rules that Congress would pass for the court and kind of how they would try and get them in line, so to speak?
Yeah, I mean, there's lots of possibilities, and there was a presidential panel or commission last fall that laid out some of the proposals that have been put on the table. So these are things like adding justices to the court, or imposing term limits, or limiting jurisdiction, or mandating that they hear more cases every year. So there's lots of different things that Congress could do. Whether it can, A, get, enough consensus to actually do any of those things is another question. And then also some of them, especially the term limit ones, have real constitutional questions, whether that's a violation of the lifetime tenure that the Constitution guarantees to judges. So we have, if you think about the New Deal court, and if that's a parallel where you think the court sort of got out of step with the majority of the country or the direction that the country wanted to go in, there, at least sort of the FDR New Deal coalition had a sort of legislative mandate, and there was only one swing justice who had to change their vote to allow the New Deal legislation to survive. Whereas here, we do not have anything like consensus on the direction the country should go in, and there's a supermajority on the court. So that, I think, public opinion was a real limiting factor in the 30s for the court in a way that it might not be this year, just because public opinion is so divided.
So in a situation where Congress passes a rule applicable to the court limiting either, we try and pack the court, or, some sort of mandatory retirement age or tenure like that, and then it's challenged on constitutional grounds, and it works its way back up through the court system, do you have these 9 justices deciding their own fate?
Well, it's interesting, right? Because the recusal rules would seem to indicate that shouldn't happen, but there are also exceptions to the recusal rules, generally, that ultimately you want to have judges hear the case. And so if all you have is self-interested judges, then I think that's what you get.
Wild.
Part of me wonders too if the political installation, the lack of political installation that we're seeing is part of just the modern era though too, where people are exposed to so many viewpoints, they're just so out in the open, and maybe it's unavoidable, but yeah, I guess we'll see.
Speaking of things being out in the air and in the open, Professor, you alluded to it earlier at the beginning of the episode, but this Dobbs opinion was leaked, which was something that, I can't remember happening previously. Seems like it was a first. And then you mentioned that the final opinion wasn't that much different between from the leak, but there was theoretically time for the opinion to change, and it gave time for the public to react, certainly. It sounds almost like a conspiracy theory. That's not what I'm suggesting, but this kind of ability for the court to test the waters, do you think that has any impact on their moves going forward? And then maybe just kind of your general thoughts on the leak and the entire situation in general, because it was unprecedented.
Yeah, I don't think that it will become sort of a routine thing. That would very much surprise me. But I do think it really worked to the benefit of the court's majority in a few ways. So one is everybody was talking about the leak. And so it sort of pushed to one side the substance of the opinion in that initial revelation. And then also having given us a preview of what was going to happen, that can sort of mute the response to the ultimate decision. If we had seen no leak and then Dobbs just came out in its full extremist glory, we already saw an explosion in response, but I think that would have been even more pronounced had we not seen an earlier version. But I think, I'm not privy to any inside information, but from what I understand, it's been really damaging to the court. It's been undermined the sort of trust that the justices have in one another. It's put all of the clerks under suspicion. They were, collecting the clerks' phones to try to track down their communications. And it's such a small institution that works, these people are like lifetime colleagues and learn to work together even when they disagree. To be in an environment like that where you feel like you're always having to watch your back makes it a much more difficult job. And so I don't envy anyone that works at the court these days.
Yeah, it seems like they're awaiting a report, maybe have conducted an investigation to figure out what went wrong, and I don't know if that results in some change of policy of of their modes of operation, but like you said, to sow maybe some level of distrust in what is already becoming a very partisan body of close working people makes me scared that maybe we lose those Ginsburg-Scalia relationships over the years and the ability for drafts to shift back and forth from kind of one side to the other, quote unquote. I don't know what that'll do to what the final opinions look like in the future.
Yeah, I think it's also just in the sense that what I think we can hope for, like the best case scenario going forward, is that these people find a way to find some middle ground on things, and the likelihood of them going out of their way to do that and feeling comfortable doing that is just a lot lower if you assume that they don't have a relationship of trust with one another. So I think it also is potentially damaging to the ability to compromise and to reach more narrow, more unified decisions.
Yeah.
I guess it's more of that kind of political entrenchment that we're seeing and potential harms on the legitimacy overall, the ability to function and make those compromises.
Yeah, it's like every other institution in the country is just not,
We're hoping
not
this one wouldn't
working
be
as
affected.
designed.
Interesting times.
Or maybe it is working as designed. I mean, it's a political institution. It's never been, or it's rarely been a partisan political institution, but it's always been a political institution. And now I think it's just fallen prey to the same thing that all of our politics has fallen prey to, which is that we have these two very evenly divided but ideologically unified sides. So there's no crossover issues anymore. And so it's all sort of you're on one side or you're on the other. And that makes it even more difficult to have institutions work as institutions rather than as, two groups that are pitted against one another.
Yeah, it seems the trend each year now, it's worse and worse, where the issues might have been on different sides of a spectrum, but that space between the issues is getting farther and farther apart each year.
Yeah.
Well, Professor, that is all we have for you today. Thank you very, very much for joining us.
My pleasure. Thanks for having me.
And we'll look forward to having you on the show again in the future, hopefully with less tenuous times.
With a happier ending, let's hope.
When con law is easier to teach and more set in stone.
There you go.
We'll wait for it. All right. Thanks so much, Professor.
Yep, thank you.
Thanks for listening. Emphasis Added is a podcast by the Houston Law Review. If you like what you saw, check us out on YouTube or your favorite podcast app.
Follow us on Instagram @EmphasisAddedPod and check out the Law Review at HoustonLawReview.org.